Hi guys, today we're going to talk about ethics in the war on terror. Let's start by thinking about how we actually define terrorism. So there's a variety of definitions that have been posed by different people. Depends on whether or not you're looking at a definition that researchers have put together, someone at the United Nations, a federal code, the FBI, Department of Defense. But the key thing we want to remember here, what makes an act of terrorism, so what makes a particular bombing terrorism versus just a bombing, okay? Terrorists are motivated by political objectives, while criminals have other motives. In the U.S., we regard terrorism as a form of war and a threat to national security. Also keep in mind there's no one or correct definition of terrorism. The term terrorism conveys moral judgments about the behavior that's being perpetrated by the group in question. And if we think about it, when we think about the term terrorist, there's really an ethical or a moral piece that comes along with that. In particular, that we're condemning someone's behavior. We also tend to think of that word as being associated with someone who's irrational and someone who's a fanatic. Our book doesn't talk about state-sponsored terrorism, even though this is more deadly and more common. So how is the war on terrorism different than a traditional war? Well, the war on terrorism incorporates elements of warfare with some significant differences. So traditional wars are one state against another state. They have a definite period of time, and they conclude whenever one party is acknowledged as the winner. The war on terrorism, however, is fought against individuals and groups of people, as opposed to states, and continues until terrorism is ultimately defeated. The war on terrorism differs in terms of the nature of our enemy. So we're not generally fighting a country, we're fighting a particular group. The location of where the hostilities are occurring, the type of tactics they use, and what is the ultimate goal of the parties involved. It also generates then a set of questions for us. We want to think about ethically how should this be conducted. So we could think about this as a criminal justice approach. In a criminal justice approach to terrorism, we would classify terrorism as a crime against humanity, and then we would file that underneath international jurisdiction. Your authors of the text note that only when the United Kingdom moved from a military to a law enforcement approach in Ireland were they actually able to drive the terrorists in Ireland out. In the U.S., criminal justice approaches have been deemed insufficient or inappropriate to dealing with the war on terrorism. And oddly enough, while we consider this a war, we don't treat the prisoners, the so-called prisoners of war, as prisoners of war under the Geneva Convention. So ultimately, if we declare this a war, we should be invoking the Geneva Convention and not the set of protections that are given to prisoners of war. Instead, we categorize prisoners of war as unlawful combatants, and they have no Geneva Convention rights. They're often held in Gitmo without a trial. The war on terror refuses to accept that any body of law applies to the way in which this war is waged. So our response to the events of September 11th has really led to us scaling back and limiting some of our rights. Wilkinson argues that we should take a hard line approach, one that remains within the boundaries of the criminal justice system. Wilkinson says we should avoid overreacting and repression. We also want to avoid underreacting. We want to adhere to the rule of law, conduct a successful intelligence war, and that intelligence agencies have to be responsible to civilian authorities and have to be fully accountable for their actions. Special legislation should have sunset provisions. So in case you are unaware of this, a sunset provision means a law is put into place for a certain period of time, and then the law automatically goes away unless specifically renewed. Wilkinson thinks terrorists should be treated like criminals and not given special status of political prisoner. We have to always counter terrorist propaganda, and we should avoid granting any major concessions to terrorists. When we do so, this creates a perception that the government is weak. In 2004, we abandoned any type of criminal justice strategy in countering terrorism, mostly because we felt that our justice system didn't have the capacity to prosecute this. Ackerman argues that the U.S. response is a state of emergency and that Afghanistan and Iraq have been packaged as battles. Battles are easier for the president to conduct. If we want to conduct a war, the president is only allowed to do so for a short period of time before needing congressional approval. So what are some concerns we might have with a military approach? Well, this can provoke a much wider conflict. It can often result in the death of innocent civilians. That, in turn, makes it difficult for us to garner any international support. It also really shifts any moral high ground that we may have had away. It's difficult to gain and have the support of our allies. A military response can sort of lead us to believe that we can totally defeat terrorism. Oftentimes, a military response mirrors the behavior of terrorists themselves. And we have some concerns about how certain we really are that any suspected person is, in fact, an actual terrorist. Wilkinson favors a law enforcement approach. This has legitimacy in the eyes of the public and local knowledge. And we're familiar with laws and techniques of investigation, and it gives us access to international sources of cooperation. So, for example, Interpol. Wilson proposes that under a criminal justice approach, terrorism would be treated as a crime against humanity. Bloom and Heyman suggest a different paradigm. They call for a new and original body of law that's both domestic and international that would provide powers that can be inserted in the space between traditional warfare and law enforcement approaches. Morally justifiable restraints. What are the morally justifiable restraints and restrictions a government should be permitted to impose on its citizens in a war on terrorism? So this is a balancing act. We're constantly trying to balance, if you think about this from Intro to Criminal Justice, we're constantly trying to balance crime control with civil liberties, and we have the same issue here in terms of terrorism. Since September 11th, we've been more willing to accept restrictions on rights and freedoms, and some feel that the ends justifies the means. Under this approach, some people feel like you could justify torture. That terrorists, by engaging in the behavior they've engaged in, have forfeited their rights. Others would argue that whenever we abridge the rights of others, that corrupts our moral high ground and promotes injustice. So the U.S. has included the U.S. Patriot Act as well as some other measures. So we've put into place new immigration procedures, new screening procedures for airlines, which most of you have probably remember from most of your lives. We have extensive databases that cover visitors to the U.S. We're doing a better job at consolidating data at Immigration and Customs. We've established the Department of Homeland Security, the Transportation Security Administration. We have a Federal Directorate of Intelligence. We've been using Gitmo, that's Guantanamo Bay. And we've also used renditions to move terrorists from country to country. When we move them to another country, it sort of allows us to not have to invoke the same rights they would have if they were on American soil. And then, of course, we have invaded both Iraq and Afghanistan. The notion of national security is challenging. We don't really have a good definition of it. It's not defined in law. Even when we do define it, it's defined very broadly. We have at times suspended habeas corpus, and when we do so, we do play into the hands of terrorist tactics. Habeas corpus requires that someone is brought before a judge in a timely fashion. When we deem somebody a enemy combatant, we are often able to suspend that requirement. We want to make sure that any counterterrorism measures we put in place, we limit to countering terrorism, that we don't use them as an excuse to investigate other criminal behavior. So Tessin argues that when we're talking about this balancing test, we should say a security measure is justified if and only if the amount of freedom it restricts is necessary to preserve the total system of freedom threatened by enemies. So how do we respond to terrorism without destroying the values? We can do this, and we can do this by setting up some tests for our leaders. So we can first ask, do whatever measures for national security we're proposing violate individual dignity? So thinking about cruel and unusual punishment, torture, extrajudicial execution, rendition to states that practice torture, and the national security measures must also pass a conservative test, okay? So we want to bar measures we don't want to suspend habeas corpus. We want to require all detention to be received by courts and ensure all prisoners have access to counsel. Essentially what the authors are talking about here is that when we respond to terrorism, we want to make sure that we're not actually restricting the rights and freedoms that we have here in the United States. That's one of the things that terrorists are fighting against, and we don't want to to borrow a inappropriately frequently used quote in the media, let the terrorists win. We want to take a consequentialist approach to counterterrorism, right? So does this make us safer in the long term? Necessary measures should be a last resort. Measures should also be aligned with any obligations we have relating to rights and freedoms in the international arena. What moral restrictions should we apply then to counter-terrorist operations? We want to refrain from indiscriminately killing, maiming, and imprisoning people who are not actually engaged in terrorist activities. Sometimes we will have excesses. There are going to be people who are casualties that are not actual terrorists, and this may be justified under the principle of double effects. So this basically says an unintended but foreseen bad effect can be excused if both the action and the intended effect are morally permissible. So take, for example, self-defense. Walter feels that this should be modified so members of armed forces should not only refrain from intending to kill non-combatants, but they should also try to protect them from being killed. This, however, of course, is going to increase the risk to safety of military personnel. So what about assassination? Is it ever morally justifiable to assassinate a leader or somebody as a counterterrorism technique? Well, Counterterror says never. An assassin has taken the law into his own hands and is judging the victim's behavior, and this violates a victim's right to life. Rachels argues that the right to life can be forfeited to, quote, eliminate great suffering, but only if the following conditions have been met. The outcome of the assassination has to be, the good of that has to outweigh the act of destroying a human life. The assassination must be the only or least objectionable method of achieving good results, and it should represent the best overall balance of maximizing good and minimizing evil. If you think about it, this is a utilitarian approach. So let's think about deontological approaches versus utilitarian approaches. And this is going to ask us to harken back to the chapters we already covered on various ethical philosophies. So Cacciadorian is applying a deontological theory. So he's talking about the only absolute right not susceptible to being overridden. So the only right we can't get rid of is the right to be treated as a moral being. A consequentialist approach to assassination would cause the public to lose faith in the justice system. If we adopted a policy like this, it would undermine the rule of law. Corlett argues that a violent reaction seeking punishment is a typical reaction. However, it lacks reflection. He urges that we react based on a presumption of innocence, a right that is so fundamental that even war cannot negate it. He also notes that any society that ignores due process is a rogue society bent on meting out what it defines as justice. So basically, we're reacting out of self-serving emotion. Is torture permissible as a counter-terrorist strategy? So the White House counsel and later the Attorney General Gonzalez advised the president that the war on terrorism was a new kind of war, and it rendered the Geneva Convention obsolete in many ways. Department of Justice said Congress had no power to regulate the president's ability to detain and interrogate enemy combatants. And then they redefined torture as extreme acts, serious physical injury such as death or organ failure. So they really sort of defined torture as the highest levels of torture. The U.S. Code, however, defines torture as intending to inflict severe physical or mental pain or suffering on another person. And this is a federal crime punishable by up to 20 years in prison. If you look at that definition, it's very different than the definition that's been used in the war on terrorism. Cacciadorian says, even a utilitarian or consequentialist approach could never justify torture in actual practice. A utilitarian consequentialist approach would forbid it. To torture a human is to treat them as an object and not a moral person. Double effect cannot justify torture. It's impossible to isolate the intention from the act itself. Alan Dershowitz, a very famous lawyer from Harvard who was on OJ's Dream Team, said torture might be applied and regulated through a torture warrant. But others argue that this is essentially going to result in judges automatically granting these warrants, and it makes it a routine matter. So when we look at warrants that are issued under FISA, those are always granted. Oh, also, some people say we could justify torture under a ticking time bomb argument. So imagine there's a ticking time bomb somewhere. Can you torture someone to get the location of it? The problem with this implies that there's a known threat. And while in that example of a ticking time bomb, there may be a known threat, in reality, in most terrorism, we don't have a specific known threat. It also implies a need for immediate action. The moral status of any alternative actions are unclear. It also claims that only torture will get us that information. We would also need that the person being tortured is the person actually making the threat as well. So a deontological approach to the ticking time bomb. A consequentialist would say, look at the good and the bad outcomes and choose the maximum good. A deontologist would say, the action would need to be right for all persons. And non-absolutist deontologists would support torture in what is deemed to be a catastrophic situation. We also have to think about the position of the torturer. Anyone capable of torturing someone is obviously not a virtuous person. People acting on behalf of the state represent the state, and we want to make sure that the state's actions are impartial and impersonal. Any state that's willing to torture someone in a ticking time bomb situation is legitimizing something that we generally consider to be illegitimate. We also know that coercive techniques do not generally grant us high quality intelligence. Many people who may be subject to torture are also often trained to withstand that torture. So in Israel, we have the only legal model of torture that exists. Between 1987 and 1999, the first model was applied after the government adopted some recommendations from the Landau Commission. In 1999, the court ruled that the defense of necessity to criminal conduct was available to people who were accused of torture. It could not be used to authorize torture, but it could be used as a defense in court after committing torture. What about targeted killings, which is sort of another word for assassination? So a government can use deadly force against enemy combatants easily identified by wearing uniforms during war. Right? So during a war, every soldier is a legitimate target. It could be killed with no advance warning. What happens, though, when we're fighting a war where people are not wearing uniforms and they're not easily identified? So both Israel and the U.S. have adopted targeted killing. This is usually through an airstrike using an unmanned drone. In the past, we have tried to kill Castro, the president of South Vietnam, and the president of Libya. And under Obama's administration, we've expanded the use of Predator drones. In 1989, the administration received some advice that said targeted killing could be permitted when there's a direct threat to U.S. citizens, even during peacetime. Once we label someone an unlawful combatant, that justifies targeted killing on the battlefield. Blum and Heyman suggested some moral frameworks for this. They said, first, the host state should be approached to arrest and extradite the suspect. We should only target people actively involved in terrorism. We want to make sure we've accurately identified the targets. We want to minimize collateral damage, and we want to only use these in the most urgent and necessary cases. Walter suggests some moral and political limits. We want to ensure people being targeted are actually those engaging in planning and executing terrorist attacks. and we want to make sure civilians are not injured. Patterson and Casale note that assassination is an immoral act. Assassination violates U.S. values and principles, and targeted killing then calls into question the morality of the U.S. foreign policy. So that's about it for our lecture on the War on Terror. If you have any questions, let me know.